Welcome, everybody. Thank you for joining us this afternoon. We will give a few minutes for people to enter the room. We're expecting a strong turnout. We have about, I would say, about close to 300 RSVPs for this CLE this afternoon. We'll give people an opportunity to enter. My name is Brian Kazuba. I'm the Associate Director for the Center for New York City Law here at New York Law School. Welcome, everyone. Okay, we are going to get started. Again, my name is Brian Kazuba. I'm the Associate Director for the Center for New York City Law at New York Law School, and we're happy to put this CLE on for you today. Thank you to JCOPE for co-sponsoring this wonderful event. We are sorry that we couldn't be doing this with you in person, but we are happy that we are still able to provide this virtual CLE. A couple of things for those of you who are looking for CLE credit. On the emails you received last week and this morning, and you will receive another email after the CLE is over, there will be forms that you need to fill out and submit as soon as the CLE is done. During this CLE, at 3 times, the moderator will provide you with codes which you need to electronically submit in order to get your credit. Please follow the instructions, and please also include your evaluations of the CLE. That'll help us determine what changes we need to make for future CLEs. So thank you for that. Thank you for joining us. And I would like to introduce the Dean and President of New York Law School, Dean Anthony Crowell, to give some welcoming remarks. Dean Crowell.
Thanks so much, Brian. I appreciate that. And welcome to all of you. As Brian said, I'm Anthony Crowell, Dean and President here at the Law School. And it is my pleasure to welcome you to this very important and timely program examining ethics and innovation in New York in partnership with the New York State Joint Commission on Public Ethics, or JCOPE. Certainly want to thank the center's leadership, Professor Ross Sandler and Brian Kazuba, who's our Associate Director, for working with JCOPE to put together a program that examines how the complex landscape we all operate within, where government, quasi-governmental, and non-governmental entities closely work together to achieve public policy outcomes. Of course, this event is taking place over Zoom as a result of the pandemic. So even in this setting, our conference involves a government agency, a nonprofit educational institution, all communicated through the technology of a private company. And the pandemic has put into sharp focus the intertwined relationship between all government and non-governmental entities as everyone attempts to develop tools to beat back COVID through technology, new medical advancements, personal protective equipment, and mechanisms to help the economy function while in-person interactions are, unfortunately, greatly limited. We're joined by a panel of some of our state's most knowledgeable experts who have years of experience navigating these complex ethical issues. I'm also very proud that our Center for New York City Law, like our other extraordinary academic centers, has continued to organize a robust array of timely events to broadcast to very large audiences. The law school and the center will continue hosting important public policy events and professional development opportunities by working closely with our government partners at all levels to give our students experiences in public service through working in clinics, externships, and positions following graduation, and to provide our alumni and friends with important programming like this. As a member of New York City's Conflicts of Interest Board myself, and as a former government lawyer, I know how important it is for all of you to have these types of in-depth discussions to help you in your daily work. And certainly convening events like this becomes an even more important endeavor while so many of us are working remotely in order to ensure we can continue to stay connected and up to date and obviously learn from each other. As we see daily, ethics is a core part of government, and working effectively and with integrity is an important function that we all must achieve. And unfortunately, during a time of immense national crisis, there are even more opportunities for corruption and ethical violations to occur. And so with so much at stake nationally and certainly locally over the coming weeks, months, and years, we're going to continue to uphold our responsibility to serve as a key resource and partner for the city and state's government's attorneys and attorneys in private practice and others who interact frequently with government. I want to thank all of you for being here today and for your extraordinary dedication over the past 7 months. Your perseverance shows how your commitment to giving New Yorkers a government with the highest integrity and ethics is paramount. I know you will learn much from these discussions and each other. Thank you and enjoy.
Thank you, Dean Crowell. Now I'd like to turn this over to Martin Levine, Deputy General Counsel for JCOPE, who will serve as today's moderator. Martin?
Thank you, Brian, and thank you to Dean Crowell. Good afternoon, everyone. On behalf of our General Counsel, Monica Stam, and myself, I want to extend a warm welcome to the 4th Annual JCOPE and New York Law School Ethics Program. Before we get started, I want to be sure to thank Brian Kazuba, Ross Sandler, Dean Crowell, and all of the folks at New York Law School for partnering with us again this year. While we would love to be in the auditorium at the Law School in Manhattan, we're excited to still be able to bring you this event as a virtual conference. I also want to thank the team at JCOPE that has put together today's program. Monica Stam, Walt McClure, Jennifer Blith, Keith St. John, and Michael Sand were all integral to today's program. Over the weekend, my wife asked me what this year's topic was, and after I explained ethics and innovation, she remarked that it was incredibly specific and also to not let things get too rowdy. I assured her that we had all learned our lesson after 2018's constitutional underpinnings of the Lobbying Act. Today's topic is, of course, ethics and innovation, navigating conflicts when the state is a partner. At the Commission, we field dozens of questions every week that ask for interpretations of the Public Officers Law. In some cases, the analysis can be a straightforward application of the ethics law to the particular facts at issue. Not to say it isn't a complex and sometimes Byzantine set of authorities, but what holds for state agency A may in many cases hold for state agency B. Whether we're looking at the appropriateness of an outside activity, how to apply the post-employment bans, or determining what constitutes a gift, the interests of the state agency, the employee, and the private stakeholder are easily distinguished such that we can identify and mitigate conflicts that could violate the public trust. By regulating the behavior of the individual, that is the state officer, we protect the state's interest. But, and this is where things get interesting, there are a few state entities for whom the answer usually involves something to the effect of, this really doesn't fit, or I can't imagine they had these facts in mind when they drafted the statute. The commonality among these entities is, as you can probably guess from today's title, that the state is standing outside its typical role as regulator of industry. In the higher education and research world, the state is an administrator of campuses, teaching hospital, labs, and other research facilities. In addition to funding these activities, it also helps staff secure outside grants, whether governmental or private. Similarly, when the issues arise out of the economic development world, the state's posture, and by extension, those of its officers and employees, is that of a public investment partner. Whether it is providing grants and loan guarantees, creating incentives, or making direct equity investments, or partnering with local businesses to drive up tourism and additional private investment, policymakers are constantly figuring out the right combination of levers to pull. And each of those combinations creates new ethics complexities. In these situations, it forces all of us, JCOPE, agency counsel, and private practitioners alike, to reassess the different stakeholders and policy interests that come to play, identify our risk tolerances, and in essence, figure out all over again what is in the public interest. As you can imagine, the questions quickly become apparent. What is the conflicts analysis under the Public Officers Law for a research scientist who pursues grants from a corporate sponsor that participates in other state procurements? Does that analysis differ under the rules of the university's granting and accreditation agencies? When we contemplate the potential commercialization of that research and the private benefits that ultimately accrue to the employee, How do we reconcile that with the use of public funds underwriting the research? Over 30,000 state employees and officials file annual financial disclosure statements, providing transparency into their private financial interests. How do we vet our private investment partners for their own conflicts? When a private entity enters into an agreement for exclusive rights to sell a product at a state event, can they then also donate funds to a state fundraising drive? Can the state solicit them for a donation? Clearly, the questions that present themselves more than fill up our 75 minutes. But our goal today is to shed some light on the thought process and analysis that our policymakers use in evaluating these issues. And for that reason, I'm tremendously grateful to the experts who've joined us today and excited to hand the floor to each of them to introduce themselves and their agencies. We'll start off with Michelle Crew, joining us from the hinterlands of Lake Placid. Michelle.
Thank you very much. I'm very excited to be here today. I'm the general counsel for the State of New York Olympic Regional Development Authority, and I am in the hinterlands. I'm up in Lake Placid in the Adirondacks. Many of you are probably more familiar with the venues ORDA operates than with ORDA itself. We're a state public authority. We were created in 1981 after the 1980 Olympics to manage and operate the Olympic facilities. We were set up under Article 8, Title 28 of the Public Authorities Law. The venues that were around when ORDA was created include Whiteface Mountain in Wilmington, Mount Van Hovenberg's Nordic and Biathlon Center, and the bobsled run in the town of North Elba, the ski jumps, the Olympic Oval in Lake Placid, the Olympic Training Center in North Elba, and the Olympic Center in Lake Placid, which is probably most well known for having been the site of the Miracle on Ice at the 1980 Olympics. Gore Mountain in North Creek and the North Creek Ski Bowl were added in the mid-80s, and Bel Air Mountain in the Catskills was added in 2012 or 2013. We are just one of 2 Olympic training centers in the United States. The other one's in Utah. We operate under a contract with the U.S. Olympic and Paralympic Committee that governs our operation as a training center and the use of the Olympic brand. We also operate under numerous agreements with the state, with DEC, for the venues that sit on state forest preserve lands and the towns that we have venues in as well. For any of you who are wondering why I included the case law that I did with the materials in front of you, is just to give you a taste of the kinds of issues that ORDA faces in operating on state forest preserve land that introduces a twist into some of our operations. Before I came to ORDA, where I've been for about 1.5 years, I was with DEC for 18 years as an environmental attorney. So my context for ethics issues and how to interpret the public officers law has been from a state agency regulatory perspective, and that hasn't really translated well to ORDA, where we have a very different mandate that, among other things, we are to promote and market our venues and to generate revenue and operate as an economic engine for the community where we have venues located. We also have the mission to operate the training center, develop Olympic athletes, provide recreation for the communities around us, to provide social benefits. But for the purposes of today's discussion, our authority to and mandate to generate revenue and how we do it is what I will be talking about today. Relevant to the introduction, I have made numerous phone calls in the last 1.5 years in getting used to my new role as a general counsel at ORDA to the public, to JCOPE, to ask questions about a lot of these issues as they've come up. And that's how I ended up on this panel today. I think that they decided it would be easier to discuss it with me in this forum than to keep answering my phone calls. So I'm hoping to learn a lot today, and I'm very pleased to be here. Thank you.
Thank you, Michelle. Next, I'll introduce Liz Fine. Liz, the floor is yours.
Good afternoon. Thank you, Martin. Thank you, Brian. And thank you, Dean Crowell. And also thank you to JCOPE for hosting this in New York Law School and the Center for New York City Law. I would just say, for those of you who are participating today, if you're not familiar with the Center for New York City Law, it's one of our gems in New York City. Ross Sandler founded it, I think, in the 1990s, and they do phenomenal programming. They have great speakers. They have really helpful publications. And, you know, I want this pandemic to be over for a lot of reasons, but one of them is so that I can attend the breakfast speakers series at New York Law School, which are always interesting. And it's always great to see so many people who are involved in civic affairs. So for that reason alone, I'm hoping that this pandemic ends soon. I am the general counsel at New York State's Economic Development Agency, Empire State Development. We're the economic development arm of New York State. Our goal at ESD is to build a strong and robust economy in New York. We want New York to be a place that people want to live, where businesses want to invest and grow, and where tourists want to come from all over the world and all over the country. We use loans, we use grants, tax credits, technical assistance, workforce development, and investment in communities and infrastructure as tools to encourage economic development. And I've spent my entire career actually in government at the federal level, the local level, and now the state level. I worked on the House Judiciary Committee, in the White House, in the New York City Council, where I had the pleasure of working with Dean Crowell when he was working for Mayor Bloomberg, and now at the state under the leadership of Governor Cuomo. I'd say, even though it's been all government all the time, it's been super interesting and challenging and rewarding. And there's no time more challenging than right now and the challenges we face in this pandemic arena. And I am honored to be with such great panelists on this panel and looking forward to this conversation. I have a lot to say just having heard Martin's introduction, but mostly I'm interested in what the other panelists have to say. So thank you.
Thank you, Liz. Next, I'm going to hand it off to Adam Haney from Suny. But before I do that, I want to remind the audience that we will have a question and answer session after the panel discussion is complete, and you should use the Q&A function in the Zoom application to submit your questions. So Adam, the floor is yours.
Sure. Hi, everyone. As Martin said, my name is Adam Haney, and I work in the Suny Office of General Counsel System Administration in Albany, New York. Suny pretty much speaks for itself. I'm sure everybody's familiar with it. But what I think is sort of interesting to share about it is, of course, we've been in existence for, over 50 years at this point, or close to in some campuses. It's a system of approximately 64 campuses, 29 of which are actually state-operated institutions. The remainder are community colleges and statutory colleges. I think we still have the greatest number of state employees across the entire state employment system, and so it certainly is a complicated process where we have federal and state guidelines, not only for ethics and conflicts of interest, but otherwise, which adds up to about there's probably approximately 50 attorneys and professional staff in our office that each work with individual campuses or issues system-wide. So it can be, it's sort of an interesting process. I've been working at Suny System Administration now for approximately 2 years, prior to which I worked as counsel at Suny Upstate Medical University and their Office of General Counsel, where, as a, health science center, we have some unique situations where there not only are physician practice plans, but also other opportunities for commercialization that occurs that happens to some degree on the comprehensive campuses, but not to the same extent. So I definitely am very excited to be on this panel. We certainly have such an illustrious group that I share the floor with here. And I look forward to not only hearing to what you have to say, but also what my good colleague Joshua wants to talk about, which is our great partner at the Suny Research Foundation, which is a contract that we created with them back in 1977, where they served primarily as our sponsored research fiscal agent, amongst many other duties and responsibilities that we've worked with throughout the years. So I look forward to the discussion.
Thank you, Adam. Finally, Joshua Tose from the Suny Research Foundation. Josh, please introduce yourself.
Thank you, Martin, and thank you everyone for putting this together and having us here today. This is going to be a really interesting conversation. So my name is Joshua Tose. I'm the Chief Compliance Officer for the Research Foundation for Suny. The Research Foundation, I guess, is unique amongst this group because we are a private nonprofit education corporation. We are not a public authority or a public benefit corporation. We're not a state agency, although we are subject to Section 74 of the Public Officers Law and certainly have many other areas of government compliance that we are responsible for managing for ourselves, but also for SUNY. Our primary job is to administer all of SUNY's sponsored programs so that if you're a member of the SUNY faculty at any of its statewide campuses who is doing funded research, we administer that research for you. We do all the financial compliance, the human resources compliance, basically any compliance activities that go along with that award and the administration of the award. And that could be for federal, state, or private dollars that come in. We also support commercialization efforts and own all of the intellectual property that's developed within the SUNY system. So we are the largest research foundation of our type in the world, supporting the largest public university in the world. I've been a lawyer for 25 years. Most of that at this point was in state government. I held a variety of positions in the New York State Senate and also in the executive branch. I worked for 3 gubernatorial administrations and also spent 10 years in the Army as a member of the Judge Advocate General's Corps. And most of my time as a lawyer, I've been involved in ethics and conflicts management. So I'm really looking forward to this conversation. Thank you.
Thank you, Joshua, and thanks to all of our panelists for agreeing to be with us today. Joshua, I'm going to stick with you to start the discussion. I'd like to focus a little bit on higher ed and sponsored research for the first few minutes and talk generally about the importance of the conflicts analysis process on not only the integrity of the research, but the institutions themselves. And then maybe talk a little bit about how you vet both conflicts with the researcher and the sponsor of the research.
Sure. Well, you know, government funding is a critical component of any research infrastructure that happens today. The Research Foundation has about probably between $400 and $600 million in government funding per year on behalf of SUNY. So obviously, protecting the integrity of those dollars through, through conflicts vetting and a really robust disclosure program is extremely important. There are a lot of overlapping regulatory schemes that I think we're going to talk about in a little bit, but it's really important not only to our government sponsors, but also to the integrity of the research that we ensure that that those involved in research are conflict free. And I think you mentioned that, vetting sponsors. I think for us, it's really important to understand where money's coming from that supports that research so that the researchers can ensure the integrity of their data. More and more today, particularly the federal government, isn't so much interested in what happens with a disclosure and what someone's outside activities are. They're more interested in the integrity of the research data. So if there's conflicting sources of funds, we want to make sure that any potential conflict that results in someone being able to call into question the integrity of the data is clarified and managed through. And I think that's, for us, one of the most important things that we can think about.
I think you've identified it right there, and the compliance process that you mentioned and the conflicting regimes is something I do want to get into a little more, but I want to pivot to Adam to talk a little bit about the dichotomy or the evaluation of commercialization of research versus the research itself, and thinking about who your client is as a lawyer for the state, and how do you prioritize those goals, and how do you advise your client in balancing those interests?
Well, Martin, I feel like that's a question I could probably talk about for the remainder of the 75 minutes. But I think, and I certainly ask, Joshua to join in to the extent he wants to add to it. But, I think that that's always the, critical part is that, faculty, of course, especially the ones that generally do more research than teaching, generally look at commercialization as an option and sometimes even a goal of either engaging in the research in the first place. And as Joshua noted, the way that it generally works is that, if a faculty member identifies something, through the use of their state job and facilities, that generally speaking, the individual would then sort of work with the research foundation to assign the patent or trademark or whatever it might be that comes from it. And then they work with the RF to then actually do the commercialization piece. So Suny doesn't directly do that in the true sense of the word, but it works with our partner who then sort of facilitates that process. So, I think at the very highest level, it's really critical that we sort of talk through that as that we're recruiting faculty to let them know that like this is a possibility, that intellectual property may generally be yours, but there's some ideas that you may need to work with the research foundation or otherwise. And so they're just fully aware of what the parameters are. And then we work closely with them through policy, as well as our partnership with the RF to like actually go through and work through what would be otherwise a conflict of interest or a conflict of commitment, to be able to come up with a plan that works both for them and us, that not only complies with our federal and state requirements, but also Suny policy as to what constitutes a conflict of interest, conflict of commitment, et cetera, amongst their various obligations of reporting through financial disclosures or otherwise. So I think it's a very complicated issue that we sort of deal with on a case-by-case basis. We have lots of policies that cover it, and it's really just a matter of making sure that faculty are fully aware of it before they sort of enter into that arena. Is that fair to say, Joshua?
Yeah, I mean, absolutely. I think that this is an area that we should be really proud of. Suny research is often life-saving research, right? So it's important for us to get it to market, but it's also important to protect the people involved in the integrity of the research. So we have a very robust control environment. The folks that I work with at the RF work very closely with Suny, Suny Council, Suny inventors and researchers to ensure that all the policies and procedures are followed, and that any commercialized technology that then is further developed is distinct from the technology that was originally created using Suny resources. So I think this is an area that we're constantly monitoring, constantly working on furthering our controls, working with faculty, developing new training, so that we can ensure that the various overlapping regulatory schemes are all being complied with.
Before we talk about those overlapping regulatory schemes, I want to highlight on something you said about the ongoing monitoring of research during its process and how you identify when an opportunity for commercialization diverges from the original goal of the research. And to what extent, or how do you advise researchers on the front end of a grant securing process? And then how do you monitor it throughout to ensure that the controls that you've put in place are being adhered to?
Yeah, so I mean, when a researcher is first getting a grant, I would say it's a fairly routine process for evaluating conflicts. The federal government particularly, and most of the funding is federal, has very robust regulations, agency by agency, very specific. So we have a whole process and a system for which we comply with those rules. Once a faculty member makes what's called a disclosure, basically saying, I have some intellectual property that we've developed and we want to think about protecting that intellectual property. So, the patent process kicks in. We also think about trying to find a business that could use that technology to create a commercializable product. And once that happens, we ask the faculty to kind of step aside. They've done the work they need to do for now, and allow the research foundation and the staff at the research foundation to work with other companies, outside groups, in order to find the right person or business to license that technology to. So at the very point where the researcher says, I've got something that potentially can be commercialized, we ask them to step aside so that they don't have any personal involvement in the business transactions around that intellectual property. And from there, we continuously work with the campus and the business to ensure that those kind of carve outs and a management plan is put in place and adhered to. Continual training, continual communication. And we have a whole group of people at the Research Foundation that do what we call tech transfer, which is the commercialization process. And they really stay in touch with the faculty and the campus staff throughout the process to ensure all of our rules are being followed.
Adam, I'd like you to talk a little bit about, and maybe this draws on your previous experience, but talk about the role of institutional review boards and the other entities you work with in the conflicts analysis process as a research project is ongoing, and how those fit together, especially, you know, in concert with the Research Foundation.
So, you know, I think that what's interesting is, you know, each campus handles it a little bit differently in terms of how, you know, the disclosures occur, how frequently people are required to do those conflict of interest checks, etc. I mean, that's usually at a minimum an annual basis, but like at Upstate, for example, they're actually, I should clarify that every campus has their own ethics officer. And then there's also a system-wide ethics officer that they can go to for, you know, any questions they may have or otherwise. And then generally speaking, sort of beyond that role, which is more of a traditional sort of JCOPE ethics officer, each of the campuses also has like a research conflict of interest board, where it's usually a panel of people from, you know, various parts on campus, whether it's, you know, physicians at a medical school or otherwise, as well as research administration, that is responsible for then, you know, going out to the researchers saying, you know, you need to do your annual disclosure, or more frequently, depending on the campus, which then also is the one that would do the review, et cetera, on an annual basis, to be able to decide whether or not there should be a conflict at that beginning point. And so then, you know, as that process continues, you know, there's an institutional review board, as you noted, which is primarily charged with, you know, actually going through to make sure that, you know, for human subjects research primarily, that all the requirements are met, which could include, you know, data integrity, conflict of interest to some degree. And so I would say it's like sort of a multi-tiered process where, you know, you sort of have the first level of, you know, financial disclosure statements, JCOPE. You have, for those faculty members that engage and are principal investigators, or doing any sort of research, there are disclosures that occur through the Research Conflict of Interest Board that also goes through, vetted through all the various panels, et cetera, in order to sort of get to the end goal. And then after, you know, a study is approved by the Institutional Review Board, you still have your ongoing obligation of doing additional, you know, conflicts checks, financial disclosures, et cetera, that go on an ongoing basis pursuant to campus policy, is also, and then re-upping with the Institutional Review Board. So there's a lot of moving parts, frankly, and that doesn't even take into account sort of what the Research Foundation is also doing on their end of things, amongst all the various trainings that need to occur, mostly on an annual or biannual basis, to make sure everybody sort of is aware of both SUNY, federal and state policy, et cetera, et cetera. So, I mean, I think that we've sort of worked out a process that seemingly flows pretty clearly to a faculty member that's done it before, but it definitely requires, you know, a little bit of training for, you know, a new individual that might be a brand new assistant professor or brand new TI, to sort of understand the different moving parts as they sort of proceed through the process.
That makes a lot of sense. Before I move on to the next question, I need to do, for CLE purposes, the first code to record. In order to get your credit, there'll be 3 total for the program. The first code is train. And again, the first code is train. All right.
Joshua, please feel free to add if there's anything that you thought I missed, but I think that pretty much describes, you know, our process for this particular research process.
No, Adam, I think that was a really good description. I would just add that both SUNY and the Research Foundation have very robust internal audit programs. So at the RF, our internal auditors regularly audit areas of compliance for financial conflict of interest and other conflict of interest. And also in the past few years, specific to IRB, the SUNY and RF internal audit teams have actually begun auditing in that area, which which is a new area of audit for us. So I think, you know, what we take back from these audits is that we definitely do more training now. We have not only the training that Adam mentioned with respect to the required training, but also really training on ethics generally and how to, and values-based training. So not specific to any policy, but just how to make better decisions, so that we teach people at the RF and through SUNY how to make better values-based choices consistent with the values of SUNY and the Research Foundation.
Well, you talk about those values overall, and this is something that I think is going to apply to all of our panelists. But that is, in every case where the venture is this overall public good that outside of a regulatory context, we're weighing priorities and we're balancing interests. And you know, specifically in higher ed, you have layer upon layer of compliance regime, whether it be National Science Foundation, National Institutes of Health, internal SUNY policies, the public officers law. When you are developing a system-wide compliance regime at RF or at any individual campus, and then it's got to, you got to be able to convey that to everyone from computer science to you know, cellular biology. You're always weighing the different interests of the different accreditation regimes, and it's not just ethics. Obviously, the IRB has a focus on safety of human testing, and so I guess the question is very holistic, but you know, how do you at every stage of the game balance these interests and stay in compliance with each of the individual institutions that have their own focus and priority?
I guess I'll start. Yeah, I mean, for us, we have obviously the federal rules, and every federal sponsor has its own rule set. Unlike the state where we have the public officers law, if you receive NSF funding and NIH funding or energy funding, defense funding, all of those entities will have different rules specific to conflict of interest and conflict management, different requirements. We also have obviously the public officers law. So for the Research Foundation, even though we're a private organization, Section 74 of the public officers law applies to us. We have our own corporate conflicts of interest policy and ethics policy and code of conduct. And obviously SUNY system has its ethics rules and conflict of interest policies, and each campus has its own ethics rules and conflicts of interest policies. And then with respect to federal regulatory compliance, different SUNY campuses treat different federal agencies differently. Some go to the standard as it's written in the regulation. Others take a higher level approach. So it does get very complicated. Again, that's why one of the reasons when I do ethics training and conflicts training, we talk about concepts and values, not specific to different policies. For me, the way I look at compliance with various conflict of interest rules is everyone needs to do a disclosure. The disclosure needs to be reviewed. If there's a potential conflict of interest that it needs to be managed, then it needs to be monitored, and the whole process needs to be documented. And I frankly don't care which system you use, which rule set you use, because if you get that core analysis done, then you can apply the specific rule set that NSF might have or NIH might have. I think definitely when we think about this, we want to minimize any burden there is to SUNY faculty. For all of the administrative burden we impose upon them and regulators impose upon them, obviously it's time away from teaching and doing research. So we try to minimize this burden, and this is an area that causes some confusion and consternation by SUNY faculty. So we're constantly training, constantly talking to people about these overlapping responsibilities. I don't know, Adam, if I missed anything.
No, I mean, I certainly would generally agree with you, Joshua. I think that, you know, at the heart of it, in many ways, the sort of spirit and themes that come out even through the various levels of conflict management or, you know, ethics, integrity concerns are, you know, inherently the same. It just might be you have to do X instead of Y, or, you know, A instead of D. And so I think that it's manageable. It's just that, you know, how do you let somebody know that, you know, normally if you were doing this just as a state employee doing X, that you'd only have to do ABC. But because you're doing it with NIH dollars or whatever, you also have to do FGH. And so it's really a partnership that occurs between us and the RF and the campus and the faculty to be able to sort of say, because of what you want to do, here's the smorgasbord of things that need to be completed. But inherently, I think they're all sort of the same sort of spirit of ideas and themes.
The public officers law, and this is going to be a theme of today, the public officers law is written and interpreted such a way that the state's interest is always paramount. And the analysis is done in a way to prevent private interests from competing with state interests. And this again is going to cover all of our panelists, but how do you interpret the law in such a way, or can you, so that it is not in conflict with notions of commercialization how do we move forward so that we have a statute and a regulatory regime that acknowledges these competing interests in the future? I'd invite anyone who wants to chime in here.
Yeah, Joshua and I have been talking a lot, so Michelle, Elizabeth, please feel free to jump in.
I'll just jump in very briefly. ORDA's issues are not anywhere near as involved as the ones that you all have been discussing. But I think part of the answer to that question is potentially in the authority given to the agency. So for ORDA, with the sponsorships and other partnerships that we are engaged in and mandated to be engaged in, we have an enabling legislation that has already found that it's in the public interest for us to carry out those functions. So I think that may be one way to rectify that potential imbalance is depending on what powers the legislature gave to the agency carrying out those functions.
And I would follow up on that and on what Adam said about, remembering who your client is, and Josh's comment about core concepts. I like to take a step back and always keep in mind what the public officers law and other similar conflicts of interest laws regulating government officials are really about. And yes, they want to encourage a high level of ethical conduct among government officials, but fundamentally what we're talking about is building trust in government and reassuring people that the work that's happening in government and the people making the decisions are acting only with the public good in mind and not with respect to their own personal or private interests, that's not what's influencing them or motivating them. And that's important for any role in government, but when you're talking about commercialization or when you're talking about investment directly in private companies, those concerns are sort of paramount. And I know with our work, there's a high level of public skepticism and questions about why are we making investments in the private sector? Why aren't all our investments just in the public sector? And we were even challenged on our ability to make grants in a case, Bordelot versus the state, and the courts ruled that yes, Empire State Development can make grants directly to the private sector, but we always have to ask with every investment that we make or every incentive that we offer, what is the purpose of this investment? What are our goals? They have to tie back to the public interest directly. And are we getting the best deal that we can get for New Yorkers? And so that's sort of the framework I think that we have to use whenever we're doing a private investment or an investment in anything that incentivizes economic activity.
Liz, I think those points are so important that you just made. I mean, that when we talked a little bit earlier about the rules that apply and how we at the Research Foundation kind of carve out the faculty researcher from the business process. And that's exactly why, right? We don't want them involved in that so that we can make sure that we're walking the legal line, right? That the public officers law is being followed. And by the way, at the Research Foundation, All of our ethics policies, our conflict policies, our code of conduct are all consistent with Section 73 and 74 of the Public Officers Law. So when we're engaging in commercialization activities, we really cut the faculty out of it and separate what's happening in the private sector, on the private side with the business versus the research that's being conducted using taxpayer dollars. And we work really hard to do that. We work with Suny Council to make sure that the faculty are doing what they need to do and the business side is being run through the Research Foundation. And I think Liz's point there really articulates the rationale behind how we engage in commercialization activities.
Before we move topics, because we're getting to that point in the on the calendar, but I want to ask, what did I want to ask? Completely lost my train of thought. Recruitment, something Adam said in his opening remarks, where commercialization is an issue in recruitment of faculty and researchers, and how do you, I guess, how do you advise folks when you bring them in, or how do you use that as an element of the recruitment process for someone who's going to be engaging in research that is, you know, sponsored by public dollars, likely sponsored by public dollars, but definitely administered by public entities? And then we'll move on to the next topic.
Well, you know, I think that we have some very, you know, entrepreneurial, innovative faculty. You know, one of the draws, I think, for SUNY compared to other places is that generally speaking, we have a very liberal intellectual property policy where the faculty is able to maintain its own interest in the IP. And so I think that's one of the reasons that people are interested in SUNY to some degree, not only sort of its ability to generate, you know, interest in, you know, because it's a large system, certainly our what's the word I'm looking for? University centers and health science centers have their own sort of draws. And, you know, some faculty come in with like, you know, they already have like a private LLC for a particular company that might be, you know, the commercialization aspect that they created and before they even decided to become faculty. And so, you know, I think in many ways, it's very much handled on a case-by-case basis, that we sort of address that as, you know, one of the things that is both a draw and potentially a concern, especially if the idea is that the faculty will then take it and then want to spin it off into its, you know, a company that's theirs, as opposed to going through the RF process, and not only with the 2-year, you know, state employment ban, et cetera, that they have to think about in terms of if they were going to continue to engage with the institution or the state. So, you know, I don't know if there's really a cookie cutter way that happens, other than to say that, you know, it's definitely on our minds and something that we, you know, address with to the greatest extent possible at the outset, both the pros and cons of, you know, SUNY and whether or not commercialization works, and to the degree that it does work through the RF, all the better, so that we can not only, you know, sort of further the SUNY name in the public interest of education and doing, you know, the public good, but also sort of reining in sort of the faculty members that really want to, you know, go above and beyond in their private life for these, you know, intellectual property interests.
I would love to be able to explore this more, and I think, you know, we could probably continue to hold this entire CLE on this question you just raised, and that is reconciling those two interests. Sure. But we do have to keep going, and so I want to talk a little bit more about the different models that the state uses in its economic development efforts. I mentioned the levers that get pulled from a policy perspective to incentivize growth and investment. So there's a quote, and I'm not sure, you know, given the economy right now, Coolidge is the best reference, but, you know, Calvin Coolidge said the business of America is business. And I want to sort of translate that to our context today and pivot to Liz and say, when you protect the venture, are you protecting the public interest, or can those interests be divergent or even distinguished?
When you protect the venture, can you protect the public interest? So, you know, it's unusual for the government to play a role as a investor, direct investor in businesses. When I was in college, that would have been considered socialism for the government to own part of businesses and take them over. We frowned, the free market proponents frowned on that. But now I'd say there's a growing trend of governments playing a role, as venture capitalists, and New York State has a venture capital program. Some of it is funded by the federal government with a particular set of rules, and some of it is funded at the state level. And we actually have two different kinds of venture programs. And we're just talking about venture right now because, as I mentioned, we do grants, we do loans, we do tax credits, we do worker training and other kinds of infrastructure investments, but just looking at venture because they do highlight some of these particular challenges of government working with a very different system in the private sector. We have two kinds of venture programs. One is a fund-to-fund program, and where we hire a fund manager, and the second type is where we do the direct investment. And each of them raises its own particular challenges in terms of conflicts. So, can the government invest? Why would the government invest in a private company? And, I like to think about Silicon Valley and the emergence there of this huge startup economy that was such an engine of growth in California. And if it doesn't happen naturally, then maybe there's a role for the state to bioengineer that. So there's a role for the state to encourage innovation. That's one key goal for these venture capital programs. There's also an effort to bring capital to regions of the state and to businesses whose owners don't typically have access to that kind of capital. So the state is sort of filling the gap there in certain industries that need the encouragement, where we want to encourage it, whether it's life sciences, whether it's green energy, and we want to jumpstart that economy in New York State. And we also want to help those businesses that don't have traditional access to capital. So we use the fund-to-fund model, and we use the direct investment model. And I don't know if you want me to talk about those, Martin, but I hope that answers your question about, can the government do it in a way that is in the interest of the public? I think ultimately that's why it's in our public interest, because if we can jumpstart a life sciences industry in New York State and really encourage the growth of green energy and a green energy economy in New York State through these direct investments in companies, that's going to benefit the state as a whole. It's going to benefit the whole economy. We're seeing that now too, less in the venture context, but in terms of our grants and loans, in investing in PPE manufacturers. So, I think we really had a hard time in March in New York State accessing adequate personal protective equipment. And we saw the need to really encourage that sector in New York State. So New York will not be in that situation ever again if there's a spike in the virus or at some future time where we can't access the personal protective equipment that we need in this state. So we've been doing grants to PPE manufacturers, we've been doing it to manufacturers of other kinds of equipment or supplies to retool their factories so that they can start manufacturing PPE. And we're doing that because it's in the public interest that we have access to it. We had people, hospitals and the government paying 7 times, I think, and I may have that figure wrong, but 7 times we were suffering from major price gouging in New York State because we couldn't access the equipment we needed. And so, was it in the interest of New York State to grant those loans and grants to PPE manufacturers? I hope so, and I hope the proof it'll be borne out over time. Not only were there jobs produced, but there's a need in New York State for that equipment.
I don't think anyone would argue that the development and the prompting of PPE distribution at this time and place is a bad thing. And I don't think anyone would argue that economic development overall is a public interest. I think, there's going to be differences in philosophy as far as how the government should be going about this. As you mentioned, the models have changed over time. And I want to bring Michelle into this. But before I go there, to follow up on that sort of philosophical bent, Liz, we saw, and in a past life of mine working down in Washington, Treasury and in Congress, we saw criticism of government intervention into markets as rescue. And we saw it as picking winners and losers. That was the criticism levied at Treasury and levied at the White House during the financial crisis in 2008, 9, 10, and 11. And if for sake of discussion, we're going to grant that premise that government intervention does result in picking winners and losers, does it change the conflicts analysis, or are the stakes just higher?
I think you have to have very clear conflict guidance, and whenever you're doing investment and working with the private sector, and it's there's so many anomalies working with the private sector, because what we hold dear and what we require of all public employees is in contrast with what happens in the private sector, and the differences are so stark. So we have absolute ban on nepotism, but in the private sector, family business is cherished. We don't allow any public employees to take gifts, but in the private sector, there's wining and dining, there's golf outings, it's just gift galore. We have restrictions on outside activities. We have a revolving door restriction. We have restrictions on use of position. Those are all in complete contrast with the private sector. So I think that whenever we're working in close contact with the private sector, and I'm not sure that this answers your question at all, but I think that we have to just keep very firmly in our frame of reference, why are we doing this? And is this for New Yorkers? And I'm not sure I think that we, as opposed to rescue versus encourage or invest, I think the key is to have our criteria for investment very clear and our goals very clear, so that regardless of what kind of investment, that you're meeting the goals of the public to strengthen the economy and to strengthen the sectors that you're looking to strengthen to advance the state's economic development strategy. And if you stick with the strategy and you have clear conflicts guidelines, I hope that the winners and losers issue becomes, fades away a little bit.
I think you did answer the question there, and that is that it is the same analysis, it is the same process. It's identifying the standards and objectives beforehand and maintaining those. We're going to come back to ESD, some of that venture capital model, but I want to turn over to Michelle. ORDA obviously has a different mandate than even ESD or certainly Suny or JCOPE for that matter. And when you enter into the true public-private partnerships with local businesses and with other investors in the Adirondacks, how do you reconcile the notion of partnering with someone without the state being an endorser of someone?
I think that's a really good question, and I thought about that a lot coming into this conference, and I hadn't thought about it before. I mean, there's so many other issues that have come up for me with reconciling ORDA's job in mandate to develop those partnerships and try to determine how that fits into the parameters of the ethics laws and regulations. that I hadn't really thought very much about that question before this conference. I think that ORDA is expected in some sense to operate as a business and in some sense to operate as a state entity. But we are a tourism destination for people from around the world. It's what the intent was when ORDA was established. And so the people that we enter into these partnerships with, I think it would be, there wouldn't be much incentive for us to enter into sponsorships, or for the businesses to enter into sponsorships with us, if there wasn't a promotion. I mean, that's why they enter into sponsorships with us, so that their products are sold by our concessionaires, or their businesses' banners are displayed during an event. And I think when we do that, we're doing it in the context of a business operation that is supposed to be generating revenue. And we have to do that with an eye toward brand protection and who they are and what our mission is and what the state's values are. And we certainly do that. But we would not have sponsors if we didn't promote them. So I think that's the short answer to your question, is that we do promote them. But I don't, I think if we were turning away sponsors, that would be a nice problem for us to have. So in that regard, I'm not sure that we're necessarily picking and choosing between winners and losers, at least not with our operations.
I think you raise a good point, and that's what is the reality of the circumstance. And you talk about different authorities granted to ORDA and different mandates. And so, it's unavoidable that when the state enters into a concession agreement or a sponsorship agreement, that there is going to be this promotion of the private interest. But as Liz pointed out, all of these involve a balancing of interests and determining what is the best outcome for the state. And so I think that's a good way of framing it. I'm going to pause for a second because I need to do the second CLE code. Second code is MOON, M-O-O-N, MOON. Okay. Liz, I want to come back to you and talk about the different venture capital models that ESD uses. And I recognize that this is just one aspect of an extremely extensive apparatus at play, but I think it does highlight the issues really nicely. We talk about ensuring that our state officers don't have conflicts, and we talk about monitoring research as it goes forward to ensure the commercialization efforts are separate from the original research. But when the state becomes an equity partner, how does it vet its partners from a conflicts perspective?
So when we do a fund to fund, we hire a fund manager. And we have an agreement with that fund manager that restricts their investments so that they can't, and this is complicated, so it restricts their investments. We actually have something that's part of all of our limited partnership agreements, a conflict of interest principles, and it restricts their ability to invest in a company where they are an insider, where an affiliate of theirs, a family member, business partner has an ownership interest or a debt or control of that entity. And to me, that's a challenging issue, because we did have a problem with one of our funds back several years ago.
Yes.
And it was with federal funding. We made an investment in a fund to fund. We had a limited partner, and that limited partner invested in 5 companies. In four of those companies, unbeknownst to us, the investor, the fund manager, had a controlling interest in those companies. Problem, right? But interestingly enough, the federal regulations allowed the fund manager to have up to 25% investment in a company that they were investing our funds in, but not more than 25%. And in this case, it was more than 25% in 4 of the 5 companies. We ended up terminating the agreement with that fund manager. It was not pretty. We learned a lot. But what was interesting to me about it was that you have a fund manager, and these fund managers, and we have a number of fund managers around the state, we're telling them in our requirements, our conflict of interest procedures, not to invest in anything that they have any investment in. And there's a downside to that, because if it's such a great investment, why didn't they invest in it? And so we're protecting ourselves, but we're also limiting ourselves in that way. So we're saying, go find something to invest our state funding in that you wouldn't invest in. And so it sort of points out the difficulty of government being an investor here. Now, clearly, we have different goals than a private sector investor, because we are trying to reach those businesses in parts of the state that don't have access to capital, and to individual businesses that don't have typical access to capital. So we have a different set of goals in that private fund manager, but we are asking them to do something you would never do probably in the private sector. So that happens in the fund to fund. In the direct investments, we actually have a advisory committee, and we work very closely with an advisory committee, and we have a conflict of interest ethics guidelines for those advisory committee members, because they are coming from places of real expertise, and they can potentially have conflicts because you don't get to have that expertise without the conflicts.
Keep losing my train of thought. We're going in such great directions here. Michelle, I want to, and Liz will come back to that, because I had something really good to say. Michelle, let's come back to you for a minute. And in an area like the Adirondacks, which obviously is a vast geographic region, but really a smaller economic one, how do you advise your staff about working on these investment projects, and then turning around and looking into opportunities in the private sector after they might leave the state? Obviously, the 2-year bar comes into play, but it's a small community, and it's a small economy. Does this change how you approach things?
Am I unmuted? Yes. That's a good question. Honestly, the people who are working on those issues for us now, many of them are new arrivals at ORDA. So this is not really an issue that has come up, other than some, we do have some employees who have left and want to go to work on similar in sports fields that interplay with ORDA, but that's a little bit different than what you're talking about. Certainly I've had the conversation with people about the lifetime bar and the 2-year bar, and training on the walls that would have to be put up if they were talking to a company that was interested in them, or they were interested in moving to. But frankly, so many of the people who are working here now are so new that this really hasn't come up yet. We're sort of going through a change in administration here, and doing things differently than they've been done in the past. So we have a lot of new staff, and that hasn't come up yet. What I would like to jump to very quickly is just to follow up on what Liz was just talking about in a much more simplified context, in terms of the limits on public operations that don't exist in the private sector. You know, when our marketing folks do work on sponsorship arrangements, we had this come up recently, earlier this year with an event that we held here, celebrating the 40th anniversary of the 1980 Olympics. And we had a gala here that Orta sponsored or Orta held and sold tables to sponsors for the event. And one of the first things some of our marketing staff wanted to do, because they came from the private sector and because this is how things work in the private sector, is they wanted to reach out to vendors that we already do business with. And I, you know, squashed that, and much to their great concern, because they said, you know, this is how this works in the private sector, and this is the best place for us to reach out to for these kinds of things. And I was concerned about the conflicts of interest and disqualified or interested sources. And ultimately, we did not seek sponsorships from any of our existing vendors, but I'm re-examining that in light of some of the powers that we have under the statute to reach out to vendors, and wondering if there are ways that we can construct policies that would engage in some vetting, so that maybe there are some vendors that would be okay as sponsors for limited circumstances, like a one-time event, as opposed to overall. And I'm just kind of interested in what other people might think about that, because this has come up several times since I've been here, and it's a different analysis, as I mentioned before, than I would have engaged in a regulatory agency.
Well, I think you've highlighted a great specific issue that has, you know, we've been in the abstract a lot today, and I recognize that, but this is a way to sort of pivot into the actual, and we'll go from here right into a few audience questions. But the question of what is a gift to the state is one I think that interests a lot of practitioners and a lot of attorneys, and it's like everything else we've discussed today, a question of priorities and balancing of interests. And so, you know, there are going to be analyses that say it should be a strict, you shouldn't solicit donations from entities for from which you already are in an agreement, or you've already done a procurement. But does the procurement model that is ideally an objective and robust model that's governed by the procurement laws or other procurement policies, does that protect against some of the dangers that come with solicitation for donations? Or, you know, should the line be a much more clear one that just simply demarcates, you know, vendors over here, or sponsors over here, and donors over here? And is that realistic?
Well, and I'll introduce one more twist into that, which is, you know, when ORDA is looking for sponsors for either an event or overall, you know, the gift provisions, we do have some gift questions, and if we have time, I'll raise another concrete example that we're looking at. But just in terms of sponsorships and existing vendors, you know, that's not, in my mind, that's not a gift. It's a bargain for exchange that is outside of the gift provisions, because we're not taking a straight donation. We're providing marketing and promotion in exchange for that sponsorship. You know, these are contractual agreements. So is this always a gift, or is there a difference in the analysis that we should be using depending on what the situation is?
Well, we could keep going from there and hold another CLE on just the gifts to the state question. I do have to address a couple of audience questions before we sign off, and this has been wonderful. I'm going to send this over to Adam and Joshua, and that is, a question came in, how are interested parties identified for commercialization opportunities? Is there a formal request for interest? It says through the contract reporter. I'll even say akin to a contract reporter. And then I'll add, you know, what's the conflicts analysis when you go through that stage of the commercialization?
I guess I'll start. We don't go through the contract reporter or variation of the contract reporter. I think when you're talking early stage technology, something that isn't even a product yet, right? It hasn't been commercialized yet. We haven't done the determination as to what what a consumer may use that intellectual property for. Oftentimes it is a small startup company. Sometimes it's actually a startup company that involves faculty or others that were involved in the research. And again, going back to what we said earlier, that is exactly why we don't allow the faculty to be involved in the process. So we kind of bifurcate the process, but we have teams of people that actually analyze intellectual property and try to figure out what the best, where to go with it, whether to patent it, how to license it, and to who and who it gets licensed to. So, you know, as long as it's consistent with our policies and particularly our conflict of interest policies, we're comfortable that we're following all the rules. But it's because the intellectual property is owned by the Research Foundation, it is I'll say a private sector process that we go through, if that makes sense.
It does, and I think it you know, sort of isolates and highlights the difference between the Research Foundation and even the role that Suny plays. I would love to be able to dig into that more with you, because I think, you know, we talked a lot about vetting external parties, but I'm wondering if the vetting of internal parties at the Research Foundation is different. But unfortunately, we are down to our last few minutes. And
if I may, Martin, just really quickly, I will say for things that are sort of outside the traditional intellectual property route that are more on the state side. So for example, if we have opportunities for outside partners to do things on a campus, those traditionally would go through like an IFB or an RFP process that would go through the contract reporter. So it just depends on the circumstances of the particular situation.
Yeah, and I think that probably would lead us back toward the traditional state agency model. So, you know, we'll save that for a different day. Let's see, another question before we close up shop. We sort of addressed that. There was a request to talk through the compliance audit process, I think in the research context, but with a little more concreteness. Is there a fact pattern that comes to mind for either of you that you might be able to use as a structure to walk us through a compliance process? Because we have, you know, sort of lived in the abstract today. And I don't want to put you in a situation where you're revealing parties, but maybe there's a fact pattern that comes to mind. If not, I can keep going.
Yeah, I mean, I'd probably have to give it some more thought to come up with a fact pattern. And I'm not even sure. I'd love to engage with, I think it's Shayna. I'd love to engage with her to try to really understand the question. Audits come in come about in a number of different ways, and a compliance audit is certainly different than kind of the typical audit. Really, when you talk about compliance auditing, you're talking more about control monitoring and process, kind of process auditing, working with owners of a process to have them walk you through it. It could be a quality assurance review. There's a lot of different things that could happen. So I'm not really sure I understand the context of the question.
That's okay. You guys have brought us a lot to work with today. Liz, I'll direct, I think, our last question to you before we do our closing thoughts, and that is, it says, do firms selected for investment also receive tax credits related to the associated earnings? And then I guess I would add to that, generally, are there controls on the different programs that entities are eligible for at ESD? Does qualification for one necessarily mean disqualification for another?
So each program that we have, and the tax credit programs are technically under our Department of Economic Development, and most of our grant and loan programs are under our ESD umbrella, but each program has a statutory basis. We don't have general grant making authority where we can just say, we want to issue grants for pie making, because we think pie making is in the interest of New York State. It has to fit the statutory goals and requirements of the grant program. And the same is true for tax credit programs. And so some investments, because we're talking about investments in innovation, jobs for the future, in tradable sectors that will encourage trade with, trading, manufacturing for trade, investments in the workforce, or placemaking investments in communities so that they are places that are livable, people who want to live there. It depends on the nature of the investment, whether it qualifies for both tax credit programs and grants. And a lot of investments are a combination of tax credits and grant or loan. But it really, you have to look at the specific purpose of the investment and see what it would meet the criteria for. And for example, the Excelsior tax credit program is one that invests in companies for growing jobs and making capital investment in New York State. And it may be that that company also could qualify for a grant program, but you have to look at the specifics of the investment, of what they're doing, what the purpose is, and why are we making that investment.
And I think that's our theme today, and that is, fitting the ethics analysis inside the bigger picture, and how those interests compete and how they reconcile. So before closing thoughts, the last CLE code is CRACKER, CRACKER, CRACKER. And I will limit my own remarks to thank you to New York Law School, to everyone at JCOPE who put this program together, and especially to our 4 panelists who were wonderful today. They all brought an insight that I think we could have spent the entire time on alone, and really demonstrate how complicated these issues can be. And so I'm deeply grateful for your participation, and take your 30 seconds and add the closing thoughts. First, can I give it to Michelle for a minute?
Absolutely. I just want to say thank you to New York Law School and to JCOPE for putting this on and inviting me to be a part of it. I've gotten a lot out of it, and I just appreciate this opportunity and the time with my colleagues here. Thank you.
Liz, go ahead.
So I want to echo that. Thank you. I learned a lot, and I always had questions about commercialization of research. So I learned a lot today. And I want to thank JCOPE for being our partner, because a lot of what we're talking about falls in that gap out, between various laws, and it's outside of the public officers law technically to deal with some of these issues, but we're guided by the principles and the advice that you give us all the time on conflicts, and we try to marry that and basically copy that and apply it in this other area. So thank you.
Well, on behalf of the staff, you're welcome. And I hope they're helpful. Adam, 30 seconds to you.
Sure. I mean, I don't want to repeat everything that my, former colleagues already said, but, I do want to thank JCOPE and New York Law School for hosting the panel. And I also want to mention, one of the things that hasn't really come up is that one of the resources that we use when we're really stumped, of course, is reaching out to you, Martin, and your team of the attorneys of the day, et cetera. That can really be a true partner in sort of figuring out some of these things that don't really fit into the traditional model. So I do want to let people know, the attendees, that also is, of course, a resource that all of us use as well. So especially with some of these more thorny issues, and they're always very helpful. So please reach out to them if you have a really sticky one. Thank you.
I certainly can't argue with that, and I appreciate the endorsement, if you will. Joshua, and then I'm going to give it back to New York Law School. So Joshua, the floor is yours, and closing remarks.
Well, again, thank you to JCOPE and the law school. This was a really interesting conversation. And it's nice to be part of this conversation and see that you're not alone. I've worked with Liz before and certainly Adam, but now I can add Michelle to the list of people I can call to troubleshoot through these things in addition to the great team at JCOPE. So thanks again for having me. It was a lot of fun.
Thank you all. Brian, I think I'm done here.
Thank you, Martin, for a great job moderating. Thank you to the entire panel, and thank you to all our guests today. So again, we have given you the 3 codes throughout the seminar. You have been emailed instructions on how to submit those codes in order to get your CLE certificate. Please be patient. You'll get your certificate within a couple of weeks, but please submit those codes through the electronic form that you have been emailed. You will receive a following email one more time with the forms shortly after this is done. But thank you all again. Thank you to New York Law School and our staff at the Center for City Law, and on behalf of Ross Sandler, Director and Founder of the Center for City Law, and Dean Anthony Crowell. Thank you for coming, and we look forward to seeing you at our next event. We have a City Law Breakfast on December 3rd with Corporation Counsel Jim Johnson. So we look forward to seeing you there, and we look forward to seeing you at our next CLE in January with the New York City Property Tax Commission. So thank you once again to all, and have a great afternoon.